Ladies and gentlemen, I would like to welcome you to this technical session on late Friday afternoon. There has been considerable discussion also during this conference on the interpretation and confines of patent-eligible subject matter, in particular by referring to US case law, where some of these issues are pending before or have been addressed recently by high-ranking courts. For instance, what is an abstract idea? What is a computer-implemented invention? When does a computer-implemented invention become patent eligible? Are DNA sequences or diagnostic methods patent eligible subject matter? How to determine whether a pharmaceutical or agrochemical patent is capable of term extension, and so on. Of course, all of these questions also arise in the jurisprudence of other legal systems, and we would like to offer you an opportunity to look into the answers given there. In particular, I'm coming from Europe. Europe has a rich and fairly complete case law system established by the European Court of Justice, the Boards of Appeal of the European Patent Office, and the national courts of the EPO member states, and dealing with patentability matters in high-tech fields such as software, life science, and pharmaceutics, fields that also seem to be of major importance for India and in particular for the Hyderabad zone. As we will see, a number of issues still pending elsewhere have thus already been answered conclusively in Europe, thereby strengthening legal certainty. Hence, patenting of high-tech subject matter in Europe seems to be relatively, not absolutely, but relatively predictable today, which may be an attractive factor for those being or becoming interested in European patents. In this session, we will first deal with patentability of computer-implemented inventions at the European Patent Office and in Germany as one of the prominent EPO member states. Then we will look into European patentability issues in life science, pharmaceutics, and agrochemistry. Finally, we will also be informed of how some of these issues are dealt with in Africa, and last but not least, in India. For reasons of time management, I would like to ask the speakers to very briefly introduce themselves to the audience at the beginning of their talk. I would also suggest to defer any questions to the end of this session. Then we will try to do our best to finish in time. Let me begin with computer-implemented inventions. Are they started? Okay. Are computer-implemented inventions patent-eligible subject matter at the European Patent Office? I'm Stefan Steinbrener, a senior consultant with Badele Pagenberg. This is a major law firm with its headquarters based in Munich and consisting of patent attorneys and lawyers. Before joining Badele Pagenberg, I was a chairman of a Board of Appeal and member of the enlarged Board of Appeal of the EPO. The specific Board of Appeal I chaired was concerned with computer-implemented inventions. So, what is a computer-implemented invention? There is a definition, or better, a description in the guidelines of the EPO. It reads, an expression intended to cover claims which involve computers, computer networks, or other programmable apparatus, whereby prima facie one or more of the features of the claimed invention are realized by means of a program or programs. Such claims may, for instance, take the form of a method of operating said apparatus, the apparatus set up to execute the method, a readable medium carrying a program, or the computer program itself, as well as the physical media carrying the program. That means computer program product claims such as data carrier, storage medium, computer readable medium, or even signal. As we will see under this definition, an important part of all applications, in particular in high-tech field, fall under this definition. So if we would not allow patents for computer-implemented inventions at all, we would cut off a major part of all modern applications. This can be seen from the statistics of the European Patent Office. The portion of granted European IT patents in 2010 was about 1/3. So 1/3 of all applications, of all granted patents in this case, relates or falls under the definition of a computer-implemented invention. Tendency growing. If you look at the law, there are two hurdles for patentability pursuant to Article 52 EPC. The first hurdle, is there an invention? Is the claimed subject matter patent eligible? And then we have a second hurdle, if there is an invention, does the invention have the required qualities? Is it novel? Is it inventive? Is it industrially applicable? I have drawn the hurdles with a different size, and we will see in a minute why. Now, the case law, I don't want to enter into specific decisions. I will only give you the summarized results. The case law found for the first hurdle, is there an invention? Yes, if the claimed subject matter has technical or technological character. And it has technical and technological character if it relates to a technical device or employs technical means. The answer would be no if it inter alia relates to discoveries, scientific theories, mathematical methods, aesthetic creations, schemes, rules, and methods for performing mental acts, playing games, or doing business, and programs for computers, presentations of information, however, only as such. That means, according to the jurisprudence, subject matter devoid of any technical implications. For instance, purely abstract or aesthetic subject matter, or subject matter not necessarily using technical means. So, if we ask the question, are computer-implemented inventions patent-eligible subject matter under the EPC? The answer is straightforward. Yes, if explicitly tied to technical means. For instance, this could be a standard computer. I could even cite a more extreme example. A method of storing data by using pencil and paper would be patent eligible subject matter. It would not be patented, of course, because not novel, but it overcomes the first hurdle. What's about the second hurdle? I've drawn the second hurdle on purpose a little bit higher. That's whereas with the first hurdle we take on board everything, is almost everything. It's very low, it's very liberal. The second hurdle is much more massive and much more difficult to overcome. Does the invention have the required qualities? No. The reason for that is the answer is only yes if those of the claimed features that contribute to the technical character are novel, inventive, and industrially applicable. That means only technical aspects count and are assessed with respect to inventive step. Features which are, or aspects which are excluded as such, are not taken into consideration for the inventive step assessment if they don't contribute to the technical solution of a technical problem. So if you ask the question, are aspects of a claimed invention excluded as such, taken into account for assessing inventive step under the GIPC, the answer would be no, unless they contribute to the technical solution of a technical problem. Now, we have at the present, for the moment being, we have abundant and substantially coherent case law in almost any specific CII field, such as computer programs, information modeling, mathematical methods, simulation design, business methods, financial transactions, information translation, graphical user interfaces, and finally computer games, and finally bioinformatics. I should add a minor question mark to the graphical user interfaces. Although the same approach is used by different boards, the results are not entirely consistent at the moment. Graphical user interfaces are a rather difficult subject matter, in particular since there are different constructions, different interpretations of what presentation of information is, whether it only relates to the contents, to the what is presented, or also to the way how it is presented. I don't want to enter into that. What I would like to consider are two specific fields: computer programs and later on business methods and financial transactions. Now, with computer programs, there is a basic difficulty. The computer is a universal machine with software, can be used in mechanics, chemistry, electricity on one hand, mathematics, linguistics, economics, almost everywhere. Now, if we do not want to grant patents for any software, we have to draw the line somewhere. With the technicality concept, one might be tempted to allow patents more on the left-hand side, which is by tradition technical, than on the right-hand side, which is by tradition non-technical. So the issue remains where to draw and how to draw the line. There's another problem. What are computer programs? They exist at different levels of concretization. We have at the top abstract information structure, elements, hierarchies, relations, etc. And at the bottom, individual forms of expression, source code, object code, etc. In between There are concrete application concepts, method steps, functional modules, etc. Now, if you look at this pyramid, we would guess that at the top level, this is not patentable. This is more or less mental act or abstract idea. And at the very bottom level, we don't need patents. This is copyright. So if patents are possible, they should be somewhere in the middle, in between. And again, we would have somewhere to draw the line. Now, the case law decided in order to be patent eligible subject matter, a computer program must produce a further technical effect going beyond the trivial technical interaction induced by any computer program and giving rise to the requisite technical character. If this is not the case, a computer program is not a technical means, the first hurdle is not overcome. Now, what could be this further technical effect? The further technical effect may in particular consist in controlling technical processes or devices. This would be the case for embedded software. Saiful yesterday, he mentioned the washing machine. Now, a computer program controlling a washing machine, such kind of embedded software would of course be patentable. But it could also consist in modifying the internal functionality of a computer. So this would, for instance, be the case for operating systems, software that modifies the computer as a platform for applications. If patentable, then the claims relating to a computer implemented method or to a computer program product with or without data carrier are possible. So, computer programs, are they patentable under the EPC? The answer would be yes, if they involve a technical application. They control a technical device or a technical process, or if they modify the internal function of the computer, which is also a technical device. The prospect of success of software patents is nevertheless rather low. We have in the IPC GO6F 940, that is more or less software-based innovations. We see the success rate is about 15 to 20% in 2010, whereas the general success rate of applications at the EPO is about 40%. So apparently the requirements are applied very, very strictly. Coming now to the patentability of business methods. Are business methods patentable under the EPC? The answer would be basically no, exceptionally rare, yes. The standard reasons for failure are business methods are excluded by the EPC as such. Inventions that means patent eligible subject matter must have technical character. Business methods traditionally are not in the technical domain, nor do they readily lend themselves to technical applications. Hence, if no technical means are employed, they do not overcome the first hurdle. If no technical means, anything technical is in the claim, they would not overcome the first hurdle. Business methods generally enter the field of technology only by computer implementation. That would mean they are tied. That would mean they are tied to maybe to a standard computer. Then the first hurdle would be overcome. But the mere automation of a possibly innovative business concept using conventional hardware and programming skills is not sufficient for inventive step, as the mere business aspects do not contribute to the technical character and thus do not count for the inventive step, and the implementation would be obvious. The second hurdle would not be overcome. This could well be seen of the prospects of success before the first instance. We have the lowest line, the green line, is the allowed, the granted patents for business methods. And the whole strategy is very nice. You see, it starts with a short jump in 1999. This was caused by the Federal Circuit State Street Bank decision. And 2 years later, when those applications entered the examination phase, the line of refusal, the red line, also jumps up. Prospects of success very low. That could only be the case if the business method is in some way related or causes in some way technical effects, which is very rarely the case. Thank you very much.